freedoms exist for the pursuit of what is good and true. And if we make the decision by enacting the First Amendment and by the way that we do our law in America to say that, okay, for the purpose of pursuing the truth and goodness, we err very strongly on the side of not letting government take sides on a particular viewpoint unless there's a really compelling reason to do so. Okay, right? Especially when we have a government that doesn't necessarily give me much confidence that they're the ones that I would want to enforce the common good and to know what is good and true. Okay, I get it. Let's be skeptical of government intervention in these things, but I think you still want to keep in mind the principle that freedoms exist for the pursuit of what is good and true, not for their own sake. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we'll be covering a recent victory for free speech at the Supreme Court in Chiles versus Salazar, which, if you're listening to this podcast, you've probably already heard about that case. I'm going to give a little gloss on that. Then we'll go over to Kansas and discuss a newly enacted pro-life law where the legislature just overrode the governor's veto and put that bill into law. And then we'll finish with a disturbing conclusion to a religion and free speech case in Finland. So let's start with Chiles v. Salazar. It was an 8-1 ruling. Like I said, I think everybody listening to this podcast is probably already aware of this case, but we'll just give a brief overview of the facts. And then rather than just summarize the ruling, which I'm sure you've read about and can get elsewhere, I will just give a couple of comments and hot takes. So this started with a woman named Chiles. She's a counselor in the state of Colorado who helps children dealing with gender confusion and sexual orientation issues. She works with them to help them feel comfortable in the body and the identity that God created for them. So there's a law in Colorado that we've covered in the past, but that basically was extremely viewpoint discriminatory, and that's important in the outcome of the case, that basically therapy, including just talk therapy, right? We're not talking about gender transition, supposed gender transition procedures and things, just talk therapy. If it affirms or explores alternate orientations and identities, that's encouraged by the law. But if a therapist talks about somebody embracing their God-given reality, who they are in terms of their orientation, their sex, and so on, that is forbidden by the Colorado statute, which obviously conflicts with Miss Chiles' way of doing therapy as well as her religious beliefs. So she files a preliminary injunction against the state of Colorado after it passed the law in 2019 so that she could continue to do her job and help children. The lower courts rejected the injunction. They claimed, interestingly, that the law was a professional regulation of professional conduct and not a speech regulation. More on that in a minute. So the majority at the Supreme Court agree that this is, in fact, viewpoint discrimination on speech, as the law prohibits one form of speech, that is a certain way of treating these sexual and gender issues, but protects and even promotes other viewpoints about these same issues. As Justice Gorsuch put it in the conclusion of his majority opinion, which I have some concerns with, so we will reread this later, but I think this quotation is important. So he says, quote, "The First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. It reflects instead a judgment that every American possesses an inalienable right to think and speak freely and a faith in the free marketplace of ideas as the best means of discovering truth." More practically on the ground, as senior counsel Adele Kim at Beckett filed an amicus brief in the case, put it, "Kids who want help accepting their bodies should be able to get it," end quote. So there's, like I said, a lot of commentary out there on the Chiles case, more expert litigators and constitutional scholars and court watchers who can opine on the overall outcome and the doctrines at play. But I want to just make a couple of high-level observations here on the case. So first of all, I'm very glad to see the Supreme Court killed this whole argument that this isn't speech, it's professional conduct, and therefore this doesn't warrant heightened free speech scrutiny. This argument is spurious and I think rather ironic. given the fact that Ms. Chiles' professional conduct that they were regulating is speech. This case was particularly chosen and brought up on the idea that there's no non-speech therapy going on, right? There's no medication, there's no anything other than talk. She engages in talk therapy. So there's literally no non-speech conduct in the type of treatment that she offers. And so I'm glad that the Supreme Court struck down the whole, this is not speech that we're regulating, because it literally is just speech that is being regulated. It might be in the setting of professional, conduct versus, speech in the public square. And maybe there's some marginal difference there, but it's speech, period. I think it's especially ironic, this idea that this was that this was conduct other than speech that was being regulated, because first of all, like I said, this is speech, but also there have been several kinds of conduct over the decades, like burning a flag, that have been classified as expressive conduct that qualify as speech. So it's a little bit of a quagmire if the free speech clause of the First Amendment encompasses certain types of non-speech, like burning a flag, as speech, but then somehow excludes what is literally speech from the protective, umbrella of the free speech clause. So I personally would have been pretty outraged if Ms. Chiles' speech in this case was classified as conduct rather than speech, because it is speech, not to make too fine a point of it. This is an important speech precedent, right? For the reasons given in the opinion. This is a stark example of a state government enforcing its viewpoint and banning alternative forms of speech, period. This is not a neutral law at all. The statute is quite clear that certain types of talk therapy are encouraged, other forms are banned. That is just viewpoint discrimination, period. It's not particularly complicated. As Justice Gorsuch notes in the majority opinion, how to treat these types of LGBT issues in the world of therapy and psychology, it's far from a settled issue, right? Yet Colorado attempts to enshrine in law the idea that exploring and affirming alternate identities and orientations is permitted, even encouraged, while trying to help people embrace their God-given sexuality is forbidden. Obviously, I'm paraphrasing, but that is the gist of the law. This is very much an example of where the free speech clause is meant to prevent government from restricting a good and important form of speech. But I would say, and this is maybe a little bit more me, I don't want to speak for all of Napa Legal here, but I personally hesitate from wholeheartedly endorsing the precedent set here, because I think it leaves some questions unanswered and leaves some problems lingering. The first one is, this type of therapy was protected only because it's speech, right? That was made very clear in the opinion. This is not conduct that can be regulated at a lower tier of scrutiny. This is speech. It's viewpoint discrimination. Strict scrutiny applies. Okay. But what about good forms of therapy that are not speech, right? I've kind of been working through the hypothetical, like in the Scarametti case that the Supreme Court decided last year, Tennessee was allowed to ban gender transition surgery, supposed gender transition surgeries for minors. It wasn't protected speech. The different categories were rejecting, suspect classes that would trigger equal protection issues. So Tennessee was allowed to ban that type of conduct without having to face strict scrutiny. So I guess my question is, does Colorado then have the ability to, for example, enforce a law banning detransitioning procedures if the government claims they're harmful, right? If somebody starts taking, sex rejecting hormones or going through these mutilating surgeries and then regrets what they have done to themselves and wants to, quote unquote, detransition, can Colorado decide that's harmful and ban doctors from those procedures? Under this precedent, I think so, because it's not speech, right? It's professional conduct, and you it if you have a good reason to say, these detransitioning procedures are harmful. I don't know. That's a case for a different day, but this certainly doesn't answer those questions about banning potentially, good therapies if they're not speech. So this is restricted to speech. And more to the point on this case, I think I have a theoretical concern with the final paragraph of the majority opinion, which I read earlier, but I'll read again here. The First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. Now, I'd pay attention to that. Any effort to enforce orthodoxy. Okay. I think it's generally true that keeping government coercion out of speech gives us a better chance of discovering the truth, because when government weighs in and tries to compel or enforce one way of thinking or speaking over another, maybe the results tend to be net negative. But this idea that the First Amendment stands as a shield against any effort to enforce orthodoxy. So government cannot enforce any orthodoxy in thought or speech. I don't think that's true, at least not as an absolute. I guess I would quibble with this because you look at the traditional exceptions to speech, free speech, for example, right? Obscenity, blasphemy in particular. These are traditionally unprotected under the First Amendment. But if you're not protecting blasphemy, right, the reviling of God, blaspheming against Christ in particular, which was the early understanding of blasphemy, isn't that a type of enforcement of orthodoxy that the government was in fact allowed to engage in? I think so. I think this shows that there are certain types of speech or expression that we find harmful and find beyond the scope of the First Amendment. I think that's just clearly historically true, because there are categories of speech where the government is essentially allowed to enforce orthodoxies, like about religion. There was always an allowance for, unorthodox debate, conversation about strange types of religion and all that, but intentional blasphemy was always beyond the pale. I use that as an example because I think it actually does contradict the idea that the First Amendment is a shield against any effort to enforce orthodoxy, because I don't think that's always and everywhere true. So even in our freedom favoring system of government, I think this idea that we don't enforce any orthodoxy in speech or expression clearly has some limits. And I'll just end with this. I wouldn't just bring this up to quibble on a theoretical level. I don't think this is a purely academic concern. What if the script is flipped, which I'm sure it will be at some point, and a state bans talk therapy, right? Like what Miss Chiles engages in, but the other way, right? So talk therapy that encourages children to explore their sexual identity, to consider alternate identities and genders, to explore sexual activity, to find who they are. That's just talk, right? Can the government ban that? Can we say that's beyond the pale, that's harmful, that's obscene, whatever it is? That's an enforcement of a type of orthodoxy in speech. We're saying there are certain things that we do not allow, even though they are a certain viewpoint. And this one, a secular and progressive viewpoint on sex and the human person. But I think that law would be obviously in promotion of the common good. Again, this is just me speaking outside the bounds of what I've talked to my colleagues at Napa Legal about. But I think encouraging kids to deny their God-given sexuality and identity is bad. That's a question for another day, but I think that's the question that this raises in my mind, right? The takeaway, I think, is just modestly to be careful that we keep in mind that freedoms exist for the pursuit of what is good and true. And if we make the decision by enacting the First Amendment and by the way that we do our law in America to say that, okay, for the purpose of pursuing the truth and goodness, we err very strongly on the side of not letting government take sides on a particular viewpoint, unless there's a really compelling reason to do so. Okay, right? Especially when we have a government that doesn't necessarily give me much confidence that they are the ones that I would want to enforce the common good and to know what is good and true. Okay, I get it. Let's be skeptical of government intervention in these things. But I think you still want to keep in mind the principle that freedoms exist for the pursuit of what is good and true, not for their own sake, right? We don't have freedom so that we're free to say or express whatever we want, regardless of the content of the message, right? We might give a lot of freedom, but that freedom is in pursuit of the truth and of goodness, not for the license to say and do whatever we want. So I think Justice Gorsuch gets at that, because in the last part of that passage that I read, he talks about we have a faith in the free marketplace of ideas as the best means of discovering truth. So we might disagree that an absolute free marketplace of ideas is in fact the best means of discovering truth. But I think this opinion does leave intact that that's the end, right? The end point that we're seeking here is the discovery of truth and not freedom for its own sake. But I guess I get a little concerned when we talk about the First Amendment standing as a shield against orthodoxy in every and all cases, because I don't think that's what it is there for. So again, Child's decision, very important, protects Colorado therapists to actually be able to talk to children about their issues and try to help them to pursue what is true and good about themselves, rather than just encourage them to go down this rabbit hole of confusion. So overall, the outcome is good. I think it's just very important to keep these fundamental questions about what freedom, especially freedom of speech, is for at the forefront as we move forward in precedents like this. So I will let you, Joseph, bring us back on track here, and curious to hear your thoughts on the Chiles case.
Frank, thanks for your really great commentary there about yes, Chiles is a victory and outcome, but there are those very valid concerns about what do we view freedom to be kind of the purpose? What do we view the purpose of freedom to be? Like you said, it's not just a good in and of itself; it's a good for something. So I definitely love when you're able to bring that into the conversation. And I just want to tie this into a bit of a broader effort that I've seen by progressive leaders to codify and enforce pro-LGBT ideology by cutting back on protected speech. Is what we saw here in Chiles. This effort to ban what they defined as "quote unquote" conversion therapy. Now, this effort, I think, is also often done by labeling speech as commercial or professional, which is then easier to regulate. We saw the same thing happen in that Olympus spa case from the 10th Circuit we covered recently. They're a traditional Korean spa run by Christians that requires nudity for a lot of its procedures, wanted to keep separate spaces for men and women. The 10th Circuit said that is a violation of the Washington state law against discrimination. And while a lot of the logic in that case is totally mind-boggling, the one thing that's really relevant to this is that part of that opinion said that the spa was also forced to post signage that said, "Oh, we don't discriminate based on this self-avowed gender ideology," or I forget the exact verbiage, but along those lines. And the court said that posting this signage is purely uncontroversial and factual, but the reality is it's very controversial. It's a fact that is being forced upon this Christian institution by a court. So it definitely isn't something that you can just say it's commercial, so we can make you say whatever we want. We saw a very similar thing in another case called EDV Noblesville. There, a pro-life student had at a public, I forget if it was elementary or high school, but a pro-life public school student got approval to start this pro-life students club, and she posted flyers for her first event. And the flyers contained pictures of people that held signs that said "Defund Planned Parenthood." It was like a stock image from the Students for Life Association that she was starting. And the school there eventually said, "We're going to shut you down. You're not allowed to post these flyers. You're not allowed to have your group because of this unwritten ban on political content." And the court ended up ruling in the school's favor and against this pro-life student based on a misunderstanding of some precedent, but basically saying that because this is student speech, it's enabled, the greater regulation is enabled. A similar, somewhat different concept in another case called Little John, which was one of those parental rights cases pretty similar to Mirabelli. Basically, a school board had this parental exclusion policy, said we're going to socially transition kids behind parents' backs, call boys girls and girls boys and vice versa, and lie to parents about it. That's more of a substantive due process claim, but ultimately what happened there is that the court said that a parent isn't able to bring a claim, the parent would lose on this claim because calling kids by their pronouns isn't the type of speech that's protected by substantive due process precedent. That one's a little bit, it's more SDP than free speech, but the same kind of concept of taking speech that's protected, giving it a different label that's easier to regulate, and then banning any dissenting opinion from a state-enforced LGBT ideology. This isn't the first time we've seen it. Obviously, some degree of speech regulation is likely necessary. You can't yell fire in a movie theater and say you have a First Amendment right to do that. Frank, you had some great comments about what a free speech maximalist and absolutist perspective, the negative things that can lead to. But we're seeing it in these efforts to enforce an ideology and silence dissent is completely unjustifiable, both under the natural law and the First Amendment. Through these efforts, protected speech is just given another label. But thankfully here, the Supreme Court saw through that mist in Chiles and ruled in favor of the truth and goodness here. So. Great. Well, with that, we'll move on to our second update. Should be a bit of a shorter one, where we'll discuss how the Kansas Legislature recently overrode the governor's veto of a bill that enables pregnant women to have the support of pro-life resource centers. So I'll start just with explaining what this bill actually does. It contains some pretty powerful protections for pregnancy resource centers. It's called the Pregnancy Center Autonomy and Rights of Expression Act. And the law states that the state government or any agency of the state government can't impose any law or regulation that does kind of one of the following. They can't force a pregnancy resource center to perform or refer abortions or provide information about abortion pills. It's great to see the language about abortion pills come in because those are so common today. The law also says that they can't prevent a center from providing its pro-life care unless it first offers or refers information for an abortion. And it also said that the state government can't interfere with the center's hiring practices and can't require the centers to interview or hire staff that won't affirm the center's mission or the pro-life procedures there. So really all of these protections say that a pro-life pregnancy resource center is free to be pro-life, and the state government can't force them to be otherwise. It also has it opens with some very positive declarations about the work of PRCs. I'm not sure what impact these would have legally, but it's still worth pointing out and a good thing to see in state law. And the bill opens by stating that, quote, the life-affirming impact of pregnancy centers on the women, men, and children in the communities such centers serve is considerable and growing. There's another line that I really like that said, pregnancy centers encourage women to make positive life choices by equipping such women with complete and accurate information regarding pregnancy options and the development of unborn children. I love it for a couple of reasons, definitely because of the explicit language of unborn children. It doesn't say fetus or zygote or whatever the kind of inhuman scientific term is. It says this is about unborn kids, and this is about helping women make decisions that uphold life. So getting more into what happened in the legislature here, Kansas has a split government. They've had a Democrat governor since 2019, but Republican control of both the House and Senate since 1992. And it's a supermajority in the legislature of Republicans in the entirety of the Democrat governor's tenure. So they've always been able to overturn her numerous vetoes. And abortion in Kansas is somewhat legal. In 2019, the state Supreme Court ruled that the privacy clause in the state constitution generally protects abortions. There have been some attempts to cut this back. In 2022, a constitutional amendment failed that would have basically said that state constitution doesn't protect the quote unquote right to an abortion. There have been other legislative efforts to curtail abortion in the state. Basically in Kansas, abortion after 22 weeks is mostly banned. But in this bill, the governor vetoed it because she said that, quote, we shouldn't be spending tax dollars trying to interfere with that very personal, very private medical decision. And this is just really something that I want to spend a little bit of time on because her veto of this bill does exactly what she says she's preventing. I wish it did prevent abortion, but this bill doesn't make abortion any harder to access. Rather, it just makes life more of an option for women. And we've talked about this a bit before, but a side that claims to be pro-choice, as we've seen time and time again, wants there to be only one choice, abortion. Pregnancy resource centers give struggling families hope through physical, often emotional, and spiritual assistance. And this bill just makes sure that they can continue doing so. This isn't something about cutting back abortion access. This is something about giving women an actual choice and cutting back against that myth that abortion is both good and the only option for struggling families. So that's what we're seeing in this Kansas bill. Very glad to see it go through. I also just want to briefly highlight that a similar bill is working through the New Hampshire legislature. Substantively, it's almost identical. It's probably built from the same kind of model language. It's slightly less aggressive in New Hampshire, but it's still working its way through the process there. And the New Hampshire government is all Republican, but there are some closer margins. This bill just passed 176 to 163 in the House, and we're still waiting on action from the Senate. So while it is a bit of a closer margin, there's definitely hope to see this go through. So that's basically what's going on here. Very good to see this bill advance in Kansas, and hopefully it'll continue to work through in a few other states. Frank, I'd love to hear your thoughts on this one.
Yeah, thank you, Joseph. Just one point I want to pick up on that you mentioned about the whole irony of the pro-choice language. We talked about this when I had Danielle White on the podcast from Heartbeat International a couple of weeks ago. She said something really interesting that the pro-abortion lobby being so aggressively opposed to any effort to allow abortion pill reversal, right, through the prescription of progesterone after someone has taken the first stage of the abortion pill. She was opining, I think convincingly, that the reason there's so much opposition to this is because it breaks the narrative, because the abortion narrative has to be that abortion is just freeing for women, makes their lives easier and better, and nobody regrets it. And so if you allow abortion pill reversal and it's documented that thousands of women are asking for it, that puts a crack in the narrative, right? Because there are thousands of people who have taken the abortion pill and clearly immediately regretted the decision, or else why would they try to reverse it, right? So I think something similar is going on here where, well, why, if people are really in favor of women's choice, why wouldn't they want more choices for women? It's literally in the phrase there. I think it's for the same reason that if you want to keep abortion normalized in the culture as well as in the law, you have to keep up this narrative that it's freeing, that it's good for women, that there's no reason to want anything other than free access to abortion. But same thing if you're funding, pro-life pregnancy centers, if you're funding alternatives to abortion that allow women to have their children, and enough women are actually taking advantage of it, it shows that maybe there's a different narrative going on. Maybe women are not choosing abortion because they're free and it's the best option, but because they feel like they don't have a choice. Because when you give them another choice and they take another choice, again, I think it pokes pretty serious holes in the narrative that abortion is harmless and women just want it and it makes them free. So with that, we will move to kind of shockingly bad news case to finish on here. Don't have a lot to say legally on it other than that it's a disturbing trend. This is in Finland. This has been going on for several years now. I don't know if we've talked about it on the podcast, but this has been highlighted all over international religious liberty outlets. So the Finnish Supreme Court found, I don't know how to say her name, Päivi Räsänen, guilty of hate speech for a pamphlet she wrote 20 years ago. First of all, it was 20 years ago, which promotes traditional Christian values on marriage and sexuality. It's not a particularly controversial piece of literature. So this has been going up through the Finnish courts for years. The Finnish Supreme Court, in a 3-2 decision, convicted this woman under a law against war crimes and crimes against humanity for expressing the traditional view on marriage. When this podcast comes out, our weekly email will also go out, and you can see there's an article from EWTN that highlights what actually has been said in this pamphlet. I want to see if I can find it before I move on, because it's really, really pretty shocking. War crimes and crimes against humanity. It was basically just following Orthodox Christian teaching in Scripture, talking about same-sex relationships as sinful and shameful. And she said in this pamphlet how this could be considered a matter of pride when Scripture calls it shame and sin is a problem. And she was convicted, yes, of a crime against humanity for basically paraphrasing the Bible. So the court heard this series of cases. This has been championed on these issues in a number of media. So there were charges against her for a 2019 tweet, 2019 radio debate, and then this 22-year-old pamphlet. The prosecutor went forward on a couple of these cases at the high court. The court acquitted her on the tweet, but convicted her on this pamphlet, which is making shockwaves in the international community because of what it signals. The court's reasoning here was that she, along with a Lutheran bishop, quote, made available to the public and kept available to the public opinions that insult homosexuals as a group on the basis of their sexual orientation. And so they're guilty of the charges before them. First of all, I would note that this war crime or crime against humanity apparently comes down to expressing opinions that are insulting to a group, which, regardless of their veracity, is quite disturbing. That an insult is apparently a crime against humanity. So the court finds. They also required that the woman destroy the reading material as well. I'm sorry, I keep referring to her as the woman because I don't know how to say her name. So I don't mean to be disrespectful. I don't know her name. So the speaker here, she wrote a National Review article recently opining that hate speech laws like this that led to her conviction are contrary to a free society. And I think there's some really interesting commentary about what's going on when we say things like free society in our current age. So I'll just end with a couple of reflections on that. So the German defense minister, Boris Pistorius, or if you remember, attacked J.D. Vance last February over Vance's spirited speech at the Munich Security Conference, where he claimed that European countries have shut off free speech in the West, and that the greatest threat to liberty is not a foreign adversary, but it's the threat within, which again caused some waves. But you look at things like this, and it seems to vindicate what Vice President Vance said, right? Cases like this seem to be the norm in a lot of places in Western Europe, including Germany, as well as Finland. Germany, for example, requires internet platforms to remove quote unquote hate speech within 24 hours. In March of 2024, raided the homes of 45 individuals for supposed online misogyny. So it looks like something of a crisis. And I think it's a crisis that's worth reflecting on. I hinted at this in my comments on the Chiles case earlier, but I think this tends to show that the absolute free society that's values neutral, I think it's unlikely, maybe even impossible for this to be sustained. We like to talk about the open society, about a place where a plurality of opinions can coexist. And of course, that's necessary to a point, but at a certain point, cohesive societies do need some unifying norms. The freedom to say or do whatever one is inclined to say or do, I don't think is a value system that can hold a society together. The breaks will just be too serious to sustain a cohesive society. And so, yeah, traditional norms about everything from faith to sexuality and marriage and what the human person is have held societies together for not a few centuries. In the last couple hundred years, we've shied away from that, moved toward this supposed values neutral public square. But in the modern world, I don't think we've simply replaced these, Western Christian orthodoxies with no orthodoxies and just limitless freedom. Instead, we find a secular orthodoxy that will not tolerate religious expressions of the truth regarding things like sexuality, marriage, and the human person. Because, like you see in Finland here or in Germany, a state that says, no, you are not allowed to express basically what the Bible says, that's not a free pluralistic society that just maximalizes freedom. There are clearly orthodoxies. You cannot say X about people who practice homosexual sexual practices, for example. That's orthodoxy. It's not a Christian one. It's not the kind of orthodoxy or unifying value that has sustained the West, but it's also not just tolerance, because it's intolerant of opposing viewpoints. So in the face of a secular orthodoxy that is clearly hostile to religion in places like Finland, what we've just seen here, it seems to me we have two options. You can either push for a restoration of norms that are in line with the natural law and the reality of the human person, or you can push for neutrality as the binding values of a society. In a world that's increasingly less religious, and maybe it's hard to garner a consensus for traditional values as what binds a society together, I understand the inclination toward the latter, pushing for freedom, maximization, and equality in the public square. But I think I'm becoming increasingly doubtful that this can work, because neutrality and pluralism just don't seem to be a tenable way to hold a society together. I think you need some binding norms that we share in common other than freedom to say or do whatever you want. So I don't know. I don't know what this will look like, but it seems that both, it seems like there's much of a place for the absolutely neutral public square, because the modern left, if you will, in places like Finland and in most of Western Europe is not pushing for this values neutral plurality. They're pushing for a different orthodoxy that's hostile to religion. So I don't know if there is a world in which value neutral is that holds a culture or a society together. I don't know that I have a solution here. I wish I did, but I think I'll just leave the question open and say that I think religious folks who are thinking about these policy and societal questions need to take this seriously, to ask, this kind of classical liberalism that champions liberty and freedom as chief values, if not ends in themselves. Is it working? Is it workable? I don't know the answer, but it's an open question that we need to take seriously. So I think I'll just leave my open question there and ask Joseph what you think before we wrap up.
Yeah, Frank, thanks so much. I loved your comments about the need for norms in a cohesive society, right? This not understanding, this perspective or belief in absolute freedom as an end in and of itself. probably isn't very tenable long term. And we've talked a bit in this podcast about how, bringing it back into our expertise, religious liberty isn't just a legal battle, it's also a social battle, it's a cultural battle. This might be a little bit tangential, and it's not what I was scripting out, so excuse me if there's any kind of rambling here, but I just recently finished a great book called Papal Economics. It's an explanation of the modern Pope's teachings on economy. And a common theme through all of these in the past 120 odd years since Rerum Novarum is that in a lot of these papal encyclicals on economics, there's not one, hey, this is what we should do. They're not going to say we're democratic capitalists. They're not saying, certainly not saying we're socialists. In fact, it's usually the opposite of that. But throughout this explanation of what is a economic system that can actually function in accord with human nature, there's not always one structural answer, but it's usually an explanation of human nature in these encyclicals itself. It's saying, what is humanity? And then from there, building what respects humanity. And I think this gets kind of to what you were saying, Frank, is that we're not going to find the social structure that just enables absolute freedom to be the thing that fits human virtue or human nature perfectly. And it's because we need to have a culture that understands truth, that is motivated by goodness, and is moving humanity towards that end. So yeah, maybe there isn't a solution of what plurality or what kind of social structure fits perfectly. It's more, what is the culture that we have? Does that fit humanity, and does that fit what we're created for?
Yeah, no, it's a good point. It's a good place to leave it, because the reality is there are norms that are in accord with the natural law, that are in accord with Western civilization, that ought to be the guiding lights that unite a culture, but our current populace and culture largely doesn't hold those. So the reality is religion in many societies in the West, and certainly in the religious freedom movement, it's not ideal, but we're on defense. And so what the solutions look like, it's a hard battle between, what's ideal, what's good, and what's feasible and realistic in the current culture. So if anybody has any sweeping solutions to the problems we've discussed here, we are always open on in our inboxes, and please reach out and let us know what you think. And with that, we have not solved the world's problems, but we've at least broached some of them. I think we'll cut it there, and just thank you for joining us for another episode of the Napa Legal Podcast. So if you enjoy the content we're putting out, we always appreciate it if you like our podcast and subscribe to the channel on YouTube, Spotify, or wherever you happen to be listening from. And if you want to find out what we're up to, including if you would like to register for our lawyers conference, which takes place at the Catholic University of America in DC on April 23rd, as well as some of the other upcoming events that we have. If you want to support our work financially, you can find all of that information at our website, napalegalinstitute.org. So you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk next week. Thanks for joining us, and God bless you.